Thank you very much.
This will only take a minute. Very briefly, as Protection Network Coalition, we feel it is important that you hear from the community directly impacted by the Chief of Police, Señor, and his department's policies. We suffer the consequences of family separations, detentions, and deportations. We feel our recommendation, when implemented, will make the city of Tucson immigrant welcoming city what we all envision it to be. So I say thank you, and here's our recommendation. Thank you, and have a good day.
I just have a couple of questions. We obviously we need to be leader in this. We need to be smart about it. Ultimately, I think I know we all agree that repeal is the ultimate answer as a state issue. Locally, there are some changes that have been proposed in the motion to the general orders. I spent quite a chunk of time going through the DVD of the AZ Post training that the police go through. And just a couple of comments on that. First of all, Mike, you mentioned the words of our practical role and won't hurt the investigation. There was quite a huge discussion in the 1051 section of that AZ Post training where they talked about that, and staffing, and call loads, and they really stress discretion on the part of the cops was something that they are supposed to be exercising, and sometimes our cops just need to be smart and not put themselves in a position where they're failing to exercise the discretion. That is allowed under the law, under the training regimen that the AZ Post puts out and all the people go through. Also on the 1051 section, and if you want to go and look at it, 44 minutes into that, the woman who's making the presentation says this: nothing in 1051 suggests it's appropriate at any time to ask a witness or a victim in criminal investigations about their immigration status. 1051 deals solely with suspects in situations of stop, detention, and arrest. That's in the training protocol, and therefore there shouldn't be any reason that shouldn't be a part of our general orders as well. And to the extent that it's included in the motion and the city manager's recommendation, in as much as that's the training our police are given, that one seems to me to be a no-brainer. And in fact, I would suggest we all might want to get a copy of that AZ Post DVD. It's really long, but it's broken up in chunks, and the 1051 section is about an hour long, and it's pretty interesting. Finally, I guess I would ask Chief, what do the general orders say about the juveniles in the presence of an attorney or guardian?
Mr. Mayor, Councilmember Kovacic, general orders deal with juvenile arrests and they do not require a parent or guardian in a normal investigation of criminal activity. I know that is one of the conditions that we're looking at in regards to how the hospital conducts their stops and their together to see if that's something that we want to do here. But at this point right now, that's not something.
I guess this is a personal, I don't think we ought to wait on Border Patrol to make that decision. I think we can do that irrespective of what they decide. We're in independent jurisdiction. You have been outspoken. I see you've been outspoken in your opposition to 1070. We all appreciate that. What is the impact? Because somebody mentioned it on your officers. I guess Rahim mentioned it.
Well, Councilmember Kovacic, I would like to respond to a few of the issues that were just mentioned by the ACLU because I really feel honor-bound to do so. I think that everyone knows and recognizes 3 years ago, and I've continually been vocally an opponent to SB1070. feel that it's not the place of local law enforcement to get involved in this type of enforcement activity. I do feel it affects our community in a detrimental fashion. It puts us in an adversarial role with segments of our community. And it goes against what we are designed to do, which is public safety and protection of everyone within our community. However, I've also been just as adamant from 3 years back to the present time that my job is to enforce the law as the law stands. We spent a lot of time through legal advisor meetings, through state chief meetings, through national meetings. I met with the Attorney General of the United States. We talked about our concerns with SB1070 and what it would bring forward and how it would affect our officers, which is exactly what is playing out in the community today. We're in a no-win situation. If I sit here and I listen to the recommendations of the ACLU, they're painting my agency as a bunch of people who are out there and abusing people and hurting people apart. And I disagree. I disagree. My people are out there enforcing the law as they've been trained to do in compliance with the law as it is written. I do not argue that the law is poorly written. I do not argue that it's a bad law. The fact is, it is a law. My officers are obligated to enforce it in a certain way. There is talk about all these complaints. I will tell you now, we have not received at either our Internal Affairs Office, the Internal Police Auditor, CPAR, or EEOC, one single complaint in regard to SB1070. When I have asked for people to come forward, when I've done community meetings, they will talk at the meeting. I will have internal affairs people there. When we ask for follow-up, there's no follow-up contact by them. But I'm very eager to deal with those issues if they're there so that we can solidify what the community's perspective is. The issue about Maricopa County attorney talking about we shouldn't question victims or witnesses. We emphasize that in our training, and that's all they did as well, because they cannot say in the policy that you cannot do that, because that is a violation of the law. We emphasize it in our training. When we did the training for SB1070, and the video that you're talking about was produced prior to the Supreme Court decision. So some of the training in that video is not relevant because it was changed after the law went into effect. We started training our officers, and we didn't rely just on the 90-minute video. We did a 4-hour training block with every officer in the department, and I personally conducted that training along with our legal advisors to make sure that we emphasize the concerns and issues that we had with SB1070. Because I predicted these type of things would happen. And I wanted to emphasize to the officers that our goal here is to do the job in a professional manner, but to not alienate the people that we needed to talk to. So we emphasize that we don't want to be questioning victims and witnesses. But I can't state a policy, and this is with review by the city attorney who agrees, but I can't state a policy that says they cannot do that. They could do that prior to SB1070, and they can do that post SB1070. But we do try and emphasize that what is the benefit to our community if we treat people in a way that they do not want to talk to us. We also emphasize the issue of practicality. On a busy night, is immigration enforcement the most important thing? Absolutely not. And we wanted to get our officers to adopt that feeling that there are more important things to do out there. But again, according to the interpretations that we're understanding and what I've received from the city attorney's office, I cannot enact a policy that says you cannot do it on a Friday or Saturday night. But we try and teach them that's not the agency we want to be. The ACLU gentleman was saying that a lot of our policies are in violation. I would love to sit down with him and a member of the city attorney and our legal advisor so that we can go policy by policy to determine which ones are in violation. And we will look at them, and then I reply with the city attorney's viewpoint because he represents the city's interests, and they will be the ones defending the city's interests. A supervisor involved in every scenario would not be realistic. Our reasonable suspicion guidelines that were mentioned were not established by TPD, they were established by Arizona Post by order of the governor. We are in the position I predicted 3 years ago. I would like to work through this position because I I do not want to lose the relationship and trust that we worked a long time within this community to develop. And I don't feel that everyone feels the same way that segments of the community do. But there's obviously a problem that we need to work through, and so I'm willing to do that. But I have to defend my officers and my agents because they're doing their job as the law dictates. I don't agree with the law, but they're obligated to uphold it. And that's what's in their difficult position. Please forgive me for the long word.
No, I appreciate the comprehensive answer. I guess I would ask in closing to you and to Mr. Miranda and Mr. Rankin, because we have a very specific motion on the table. If you're comfortable both procedurally and legally with what we're being asked to vote on, and Mike, for you in particular, that quote that I read out of the AZ Post training, and I'll reread it. Nothing 1051 suggests it's appropriate at any time to ask the victim or a witness in a criminal investigation about status. It doesn't talk about you can't talk to them. It specifically says nothing suggests you can ask them about status. If the training that our police officers statewide are given specifically says that, why does that put us in jeopardy if we adopt it as a general order? And so to the chief and to Mr. Miranda and to Mr. Rankin, are you comfortable both procedurally and legally with what we're about to vote on?
Mr. Mayor, Councilmember Kozaczek, yes, I'm comfortable with the contents of the motion. With respect to your second question, the motion incorporates the direction and request that the language with respect to the interactions with victims and witnesses be phrased as strongly as possible with respect to constitutional rights and the priorities of the department, which the chief has laid out very clearly here today. So we will look at that resource that you've identified as well as others to see how far comfortably we can go with that language.
Councilmember Pembroke.
Well, procedurally.
Mr. Mayor, Councilmember Kozaczek, the communications and the motions that have been drafted have been in concert with my office, the city attorney's office, and the chief of police. So obviously the path will be going forward and then
Chief?
Mr. Kozaczek, when that training video was put together, I'm not sure if that part was pre-proposed that Supreme Court decision. My concern with what you're proposing is that that sounds like we are enacting a policy that restricts full enforcement of federal immigration law and back into the city attorney. But I would defer to the city attorney's opinion on that.
Okay. Councilmember Pembroke.
Chief, your policy that you currently have in place, when's the last time you revised it and reviewed it, and who reviewed it with you?
These policies were all put in place with the city attorney's office and my legal advisor staff. For your issue, you see at the top date of each of the policy, it will have the issue date of September 2012 as well as any revision policies on there. I'm looking at it right now to see if there's anything that would be since then.
There was a June 30th, 2013 revision with respect to the 2019 series of journals.
Okay, so the changes that the Supreme Court made, we've adhered to that and incorporated them into the changes.
And we look at them.
How do we get that out to the troops, the training? How does that process work?
The initial training took place when we brought every officer into the station and we trained them for a 4-hour block.
So everybody that's on the beat got this training?
The existing officers, when the law went into effect, got a 4-hour block. The new officers get that training within the academy.
And how do our